Welcome to Minds of Aspirant. In this Expound series, in this week, we will see about the topic which captures the recent headline. We have recently appointed Chief Justice of India, and who is going to be the 50th Chief Justice of India. In this video, we will detailedly discuss about the post Chief Justice of India and what the Constitution is saying about the post Chief Justice of India and what is the importance of holding this post. We will detailedly discuss about everything regarding this topic in this video. Stay with me until last of the video, and if you don't yet subscribe to the channel of Minds of Aspirant, I request you to please subscribe this channel. And if you are aspirants studying for UPSC or TNPSC exams in Tamil language, the same video which is in the language of Tamil, it is also posted in an Minds of Aspirant channel. So before going into the channel, I request you to subscribe this channel. So regarding the news, recently we have appointed a new Chief Justice of India, and who is D.Y. Chandrachud. And there is an important thing about him when compared to last decade, last 10 years. If you take all the Chief Justices of India and their tenure, he is going to have the maximum tenure of 2 years. So all the previous Chief Justice of India have very short tenure of 6-7 months to 1 year, and of course last Chief Justice of India, Justice U.U. Lalit, has very short tenure of only 72 days. So succeeding U.U. Lalit, the next Chief Justice of India is going to be D.Y. Chandrachud, whose tenure is about 2 years, which is largest in this decade. And there is an irony that his father, Mr. Y. Chandrachud, he is known for holding the post of Chief Justice of India. His father is also a Chief Justice of India. He is known for holding that post for very longest serving Chief Justice of India is his father, Y. Chandrachud, and he holds the post for around 7 years. So these are the important thing about D.Y. Chandrachud. His father is also an Chief Justice of India, and he is going to be the India's 50th Chief Justice of India, and he is going to be appointed on November 10th, 2022, and he will work for 2 years, and he will retire again on November 10, 2024. Retirement, and considering his age, maximum age of 65. So he will retire at the reaching his maximum age of 65. So of course in India, all the Chief Justice of India, all the judges of Supreme Court, all the judges of High Courts are appointed by President on the recommendations of Prime Minister, in which Prime Minister is recommended by Law Minister. So all the Supreme Court judges and High Court judges in India are appointed by President according to Article 124. So other judges lower than High Court judges, lower court judges, district court judges, those judges are appointed by governors of that particular state. So these are the factual things related to the judiciary. So current President Draupadi Murmu has administered the oath and affirmation to the G.Y. Chandrachud, current Justice Chandrachud at Rashtrapati Bhavan. These are the important catchy events. So regarding the constitutional provisions, what the Constitution is saying about Chief Justice of India, we should look into this Article 124. So Article 124 has clearly mentioned that there shall be a Supreme Court. So there shall be a Supreme Court, one Supreme Court of India. And with that Supreme Court, there shall be one Chief Justice of India. In that Supreme Court, one Chief Justice of India, along with Chief Justice of India, 7 Supreme Court judges. So these are the things which are mentioned in Article 124 about the judiciary. So later subsequently we amended this article by a normal amendment. This amendment will not come under Article 368 amendment, special majority amendment. This is considered as an other amendment which the Constitution can be amended by using Article 368 special majority. Constitution can also be amended by using simple majority also. So in that category this amendment will come. So after subsequent amendment, currently our Supreme Court holds a strength of one Chief Justice of India plus 33 judges. So on the whole we have now 34 judges. 34 judges at present. So constitution didn't mention about how to appoint Chief Justice of India, what are the procedures to be followed while appointing Supreme Court judges, what are the procedures to be followed while transferring the Supreme Court judges, High Court judges. The constitution never mentioned about anything. There was a synergy between the government and the judiciary until 1973 regarding the appointment of Chief Justice of India. But on 1973, due to that emergency crisis which is declared by Srimati Indira Gandhi, there was some internal tussle between the government and the judiciary, and there some disruptions has happened. So we will see the series of judgments after 1973, and we will come to know about the birth of collegium system also at the end of this video. So in this slide, Article 124 clearly mentioned there shall be a Supreme Court consisting of Chief Justice of India with 7 judges. These 7 judges has been subsequently increased to 33 judges right now. And Constitution in Article 124 Clause 3 also mentioned there are some qualification to be there in order to appoint as a Supreme Court judge. Of course, Constitution also mentions some qualification which are needed for High Court judges also, but right now we will restrict our discussion to Supreme Court judges. Of course, Supreme Court judge, one of the Supreme Court judge is going to be elevated as a Chief Justice of India. So now we will see what are the qualifications which are mentioned in the Constitution under Article 124(3). What are the qualifications that are needed in order to become a Chief Justice, Supreme Court judge. So the qualification can be, two qualification is necessary. Either he or she should be a citizen of India. That is the first and foremost qualification. It's mandatory qualification. He or she should be a citizen of India. The other qualification can be either A or either B or either C. So these 3 qualifications are needed in order to become a Supreme Court judge. So the first option A, the provision number A is he or she should have the experience of 5 years as a High Court judge. He should have an experience of 5 years as an High Court judge. If he has an experience of 5 years as an High Court judge and he is also a citizen of India, then he can be elevated to Supreme Court judge by collegium. We will later see about this collegium. These are the qualifications which is mentioned in the Constitution itself. The other category is either 5 years as a High Court judge or 10 years as an advocate. Or eminent jurist in view of president. So eminent jurist in the view of president. These are the 3 provisions. So either this or this. You should a person should have either he should be a citizen of India, and either of these qualifications he should possess. So maximum number of Supreme Court judges comes from this category. At currently D.Y. Chandrachud is also came from this category only. He served 5 years as an High Court judge combinedly from Allahabad High Court and Bombay High Court, and then he is elevated as a Supreme Court judge, and now according to senior most position he has become a Chief Justice of India. So 10-year advocate, these are the person who are directly elevated to Supreme Court directly from the bar. For example, there will be very few judges who are directly came from bar to Supreme Court. Among them, few Supreme Court judges, only 2 has elevated to Chief Justice of India position. For example, at current UU Lalit, he directly elevated from bar as a Supreme Court judge, and from Supreme Court judge to Chief Justice of India. He is the second person. The first person is Justice Sikri. So these are the only 2 persons who have got the chance to become a Chief Justice of India directly elevated from the bar. And the last position is eminent jurist in the view of president. If president thinks if he is the fit person to become an eminent jurist, he can recommend, he can appoint. But till now, no person has been appointed as a judge under this eminent jurist category. Constitution also silent about this jurist. The only clear thing is the jurist should be a member who holds a degree of law. He should be rich in law. That is the only condition. Till now, no one has appointed in this category. And also note that for appointing High Court judges, this provision is not there. For only Supreme Court judges, this eminent jurist condition is there. So these are the qualifications which are mentioned in the Constitution regarding the Supreme Court judges. Now we will look into about this collegium system. So regarding this Chief Justice of India, regarding the appointment of judges, you will come across the term collegium then and there in the newspaper. With this slide, you will be clear about this collegium concept. So from 1950, when we adopt the constitution, until 1973, as I already said, there was a synergy, there was a cordial relation between the government and the judiciary regarding the appointment of judges and the appointment of Chief Justice of India. So what happened in 1973 in emergency situation? There was an emergency crisis, and those cases was taken in the judiciary, and one of the judge was H.R. Khanna, and he gave a dissenting judge against Indira Gandhi. So Indira Gandhi got provoked, and what she did, he is the person to be appointed as the next Chief Justice of India according to senior most position. But Indira Gandhi didn't recommend his name, H.R. Khanna, for either recommending his name. She recommended A.N. Roy. So on protest of this, H.R. Khanna has resigned from that post. So until 1973, there was a synergy. At 1973, due to this issue, there was some disruption between the government and the judiciary regarding the appointment of the judges, because most of the cases in Supreme Court judges, the one of the party will be government. So if the judges are appointed by the government, then of course we cannot see the judgment in an unbiased condition or neutral condition. So that's why there should be a separation of judiciary from the executive, which is enshrined in the Article 50 of DPSP. Directive Principle of State Policy. In Article 50 clearly states that the judiciary should be separated from the executive. So this case went into court in the Supreme Court, first judge's case 1982, which is famously called as S.C. Gupta case. So in this case, Supreme Court clarified about that Constitution mentions that the next Chief Justice of India, next Supreme Court judges should be consulted by the present Chief Justice of India. I mean, present Chief Justice of India should be consulted before any appointment. But this consultation never means concurrence. So consultation never means concurrence. Consultation is just telling. Concurrence is getting getting go ahead. That is what concurrence. The first judge case 1982 said that consultation is never mean concurrence. That means Chief Justice of India don't want to agree into that appointment. Just consultation is enough. That is what the outcome of the first judge's case. In second judge's case 1993, the Supreme Court said that reiterated its earliest verdict. It changed its earliest verdict to this consultation is mean concurrence. That means that Chief Justice of India should agree to the further appointment. That is what this consultation, the term is meant. And they didn't stop on that. They also said that not only Chief Justice of India, he can include some other judges also. So from here, the birth of collegium happens. In second judge's case. So these are the things which are made in order to appoint the Supreme Court judges without the intervention of the government, in order to attain the independence of the judiciary. So in second judge's case, collegium was said, but they failed to define what is collegium, what are the constituents of the collegium, who are the members of the collegium. They failed to define that. This was defined in third judge's case. In third judge's case 1998, the Supreme Court come up with a collegium structure, and collegium structure will consist of certain number of judges, and they will appoint the other Supreme Court judges, they will transfer the other Supreme Court judges, they will do all the judiciary appointment. This is what the outcome of the third judge's case. So I am sure you are clear about what is mean by collegium system. So I'll say again for you, 1950 to 1973, there is nothing to worry. The senior most judge is elevated to Chief Justice of India. But in 1973, there was a tussle between H.R. Gupta, A.N. Roy and Indira Gandhi, and somehow the senior most guy, H.R. Khanna, is neglected and A.N. Roy is appointed. There happens the tussle, and in first judge's case, second judge's case, third judge's case, the outcome of the case, there comes a collegium system. Collegium system consists of certain number of judges. They will appoint without any intervention from the government. This is what the collegium structure. Now we will see what is the constituents of this collegium structure. The first one is, in order to appoint a Supreme Court judge, there should be a collegium, right? Collegium, no government intervention. Judges will appoint the judges. Only in the world, in India, judges will appoint judges itself. They will appoint their brothers. So appointment of Supreme Court judges, it will consist of one Chief Justice of India, right? One Chief Justice of India plus 4 senior most Supreme Court judges. They will recommend the other person who are eligible to become a Supreme Court judges. So regarding the appointment of High Court judges, there also a collegium system is there. There are also one Chief Justice of India is there. With him, 2 senior most Supreme Court judges enough, because it is High Court, right? For Supreme Court 4 judges, for High Court 2 judges is enough, 2 senior. This collegium should recommend the names to Law Minister. Law Minister will move the file to Prime Minister. Prime Minister will advise the President. President will appoint. So these are the structure. These are the structure. And in order to transfer, look carefully, in order to transfer the High Court judges, there should be again a collegium should be there. Usual, of course, one Chief Justice of India will be there, and with him 4 senior most Supreme Court judges will be there, and with him the transfer of High Court judges, right? Then there will be 2 High Court judges involved. For example, Allahabad High Court and Madras High Court. Those 2 Chief Justice of High Court. So on the whole, 6-7 members will be there in order to transfer a judge from one High Court to another High Court. There will be 3 judges in order to appoint an High Court judge. There will be 5 judges in order to appoint a Supreme Court judge. So this is what the collegium system clarifies to the regarding the appointment structure. So at present there was some changes in the collegium. At present there was a changes in the collegium. Usually the collegium will consist of the Chief Justice of India plus 4 senior most Supreme Court judges. But on contrary, at present collegium consist of 5 senior most Supreme Court judges. The extra one senior most Supreme Court judge is for because there is a reason. This Chief Justice of India will retire at the age of 65 years, right? This Chief Justice of India will retire at the age of 65 years, and all the 4 senior most Supreme Court judges will retire before the retire of D.Y. Chandrachud, because he has a long tenure of 2 years. So in order to avoid that, this collegium should consist of a judge, 4 senior most Supreme Court judge. One should be a candidate for the next Chief Justice of India. One should be a possible player of next CJI. But at present, unfortunately, these 4 senior most Supreme Court judges will retire before the retirement of the Chief Justice of India. That's why the other one was added. Fifth Supreme Court judge was added in order to make sure that one judge is there who will become as a next CJI. So in order to attain that, the other other Supreme Court judges added in this collegium. That's why at present alone Chief Justice of India plus 4 senior most Supreme Court judge will be present. So this is what some changes in the collegium structure which you will find in the news recently then and there. So these are the things about Mr. D.Y. Chandrachud, his position and the birth of collegium. I'm sure you are well aware about now that the birth of collegium. So regarding the outcome of 3rd judge's case, the collegium structures has came. And after that, in 2015, government has made a constitutional amendment, 99th constitutional amendment, and made a provision for National Judicial Appointment Commission. National Judicial Appointment Commission is nothing but a commission which holds certain number of judges, certain number of members from the government side in order to appoint the judges. So judiciary done that, 99th amendment will be void. Judiciary cancelled that. So judges will be appointed by judges itself. In order to maintain that independence, this National Judicial Appointment Commission stands void. This is what the verdict of the judiciary. So at present, judges are appointed by judges itself by the process of collegium. Now you understand what is meant by the collegium. And from this you can say that what some criticisms also there regarding collegium. We don't want to go very much deep. By looking at a plain manner, you can say a first criticism that brothers are appointed by brothers. This is what the catch they will use. So they will appoint their son, they will appoint their relatives, they will appoint there will be a nepotism. There is a chance for nepotism in collegium system. And what are the judges discussing inside this collegium? No one knows outside. That is more opaque in nature. That is what another criticism. It is more opaque. Their recommendations only coming out of the collegium. There is no we don't know what they are discussing. People don't know what they are discussing. Government don't know what they are discussing. So that is more opaque in nature. So these are some criticism. And one of the main advantage of collegium is independence. So they can attain a very much good independence. Judiciary independence will be attained by this collegium system without the interference of the government. So that is a more positive step in order to give a unbiased verdict. So these are the some important things regarding the collegium system. Thank you for watching Minds of Aspirant series. Please don't forget to subscribe this channel. Please share this channel. Please share these videos to your fellow aspirants who are preparing to the exam. And the same video which I have discussed in the English, which is which I have also discussed in the language of Tamil and also uploaded in the channel Minds of Aspirant. So do check that video also. Thank you for watching Minds of Aspirants.